Generally, a criminal defendant is entitled to a specific jury instruction on a reasonable mistake of fact defense when the mistake negates the existence of the necessary mental state to commit the crime. But what if a defendant's mistake of fact defense is covered by the court's charge to the jury of the general elements of the charged crime? Is a criminal defendant still entitled to a specific jury instruction on it? In Hopson v. State, the Texas Court of Appeals considered this question in a case involving a burglary. In July of 2007, Karissa Lou Hopson was arrested after police officers found her standing on the front porch of a house holding a television. Hopson claimed she knew the homeowners and had their permission to be on the property. However, the police noticed the home's windows were broken and that Hopson had blood on her shirt and hand. Further, the homeowners said they didn't know Hopson and didn't give her permission to be on the property. Hopson was charged in state district court with burglary and criminal mischief. She pled not guilty to both charges, and the case went to a jury trial. At trial, Hopson testified she went to the home to visit the homeowners, but when she arrived, she found a man taking things out of the home. Thinking the man was stealing, she confronted him, and he left. Afterward, she picked up the television on the porch and intended to return it. Consequently, Hopson claimed her intention wasn't to commit a burglary, but to prevent one. Following her testimony, Hopson asked the court to give a mistake of fact jury instruction. The court denied the request and instructed the jury that, to convict Hopson, it must find she entered the house without consent and with the intent to commit theft. Further, the court instructed the jury that it must acquit Hopson if it found the state didn't prove that she intended to commit theft. The jury then found Hopson guilty of both charges. Hopson appealed to the Texas Court of Appeals, arguing that the trial court erred in refusing to give her mistake of fact jury instruction.